Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
Hello, and welcome to another edition of Engaging Experts. This is Dan Rubin, the National Business Development Manager of Roundtable Group, and also one of the hosts of this podcast series. We have another great guest for you today. Kirk Watkins is of Counsel with Davis, Zipperman, Kirschenbaum and Lotito, LLP in Atlanta, Georgia, where he focuses on complex commercial litigation, intellectual property litigation, and international and domestic arbitration disputes. Over his 35 years as a litigator, Kirk has regularly been listed as a best lawyer and super lawyer, both in Georgia and nationally. Kirk is also a certified mediator, having served as past president of the Atlanta International Arbitration Society, where he currently serves on the executive committee of the board of directors. Kirk, welcome.
Thank you. It's great to be here.
Well, I'm looking forward to a great discussion. But first, let's pause for a brief sponsorship message.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
So, Kirk, tell us, what took you into the practice of law initially? Did you always want to be a litigator?
No, it's funny. When I was a young kid, I wanted to be a book writer. And in fact, I was on the Popeye Club once on television, and the host asked me what I wanted to be when I grew up, and I said a book writer. But as it turned out, in high school, one of my great friends was, in fact, a very, very good writer. And when I read what I was writing and read what he was writing, I decided that he was a much better book writer than I was, so that I better find an alternative career. And I began my search for the profession of law at that point in time in high school.
Gotcha. So you started your career with Troutman Sanders, and then you moved on to a smaller firm, if I'm not mistaken.
That's correct. I started at Troutman, had 2 fine years there, great law firm. And then had an opportunity to move to a smaller firm, Parker, Johnson and Cook at the time, later became Parker, Johnson, Cook and Dunleavy before merging with Womble Carlyle. When I first joined them, I was the 5th lawyer, the only litigator, and with 2 years experience, got to be first chair on all their litigation cases, which was both an extremely challenging and fun experience and scary to death. It's like being thrown off into the deep end when you're about 5 years old. But you sink or swim, and I learned very quickly how to swim, not without a few bumps and bruises, maybe a gasp of water now and then, but it worked out real well, and I felt like I've always felt like, as far as training younger associates, the sooner that you can put them in the courtroom, and the sooner they are challenged to rise above their current competence and experience level, the faster they will rise. It's good to be there to help them a little bit, but it's not necessarily good to be there and take over from them. It takes away from the experience.
Right. Well, so during that time, so I guess it's over 35 years between the combination of Parker Johnson and then Womble Carlyle, you must have had some a lot of noteworthy cases in that time. Are there any in particular that come to mind?
There's one case that does particularly come to mind that I enjoyed thoroughly. It was representing a company called Pacific Communications, and I worked closely with their 2 owners, Stephen Johnston and Sanford Thomas. And we took on a host of opponents out of Jackson, Mississippi, with a company called American Wireless, and had a really invigorating, challenging trial and case that lasted fairly brief for the size of the case. We had an interesting situation. We had filed initially in Georgia, and our opponents filed in Mississippi with the same parties, and went to Judge Constance Russell in Georgia, and I was trying to enjoin the Mississippi case because it was the same parties. And she said, well, I can't enjoin the case in another state, but I tell you what I can do. It is a Georgia statute which says if you bring suit in Georgia and the opposition brings the same suit in another state, that you can move to the first position on the trial calendar. So there I was 2 or 3 weeks into my case, and the judge asked me, with my opponents in the room, was I ready to go to trial the next week? And I said, I certainly am, Your Honor. and my opponents certainly were not ready, and not that I was so much ready myself, but in any event, they agreed to stay their own suit if the judge would give them 3 months. So we had 3 of the most hectic months getting ready for a trial that I can remember. And it was a lot of fun getting ready for it. And it was a lot of fun during the course of the trial. And I had a young at the time associate, Anna Davis, working with me, who was very confident of her abilities and almost as good as she thought she was, and getting better every day. And we worked together against seven partners in a law firm out of Mississippi and a major, highly respected individual here in Atlanta as well. And so it looked like to the jury that we were greatly outnumbered. And during the course of the case, I had one experience with her that was terrific. I've always felt like if you have an attorney during the course of a case that sort of grows in front of the jury's eyes, that they pull for that attorney. They really identify with them and want to see that person do well. And Anna performed that role perfectly. She had a rough start with one witness and was worried I might not let her take another, and I gave her a very difficult witness the very next day, and she did a terrific job. But during the course of the case, I was presenting some exhibits to the jury at one time, and I was using Trial Director, and my scanning device that I scanned on the barcode to bring up the exhibits was not working. So I was relating to Anna the exhibit numbers that I needed her to pull up on the screen for me, and I was making a few errors and giving her the wrong exhibit numbers. And so there I was in front of the jury with the wrong exhibit behind me. And after I'd done that 3 times, I apologized to the jury and told them that it was my fault. It wasn't the fault of my help. And the judge, she rightfully tuned in right away to my use of the term "my help," which was not an appropriate terminology to use for anybody working for me. And I had not been thinking of that in that way. And all of a sudden, she said, "What did you say, Mr. Watkins?" And so I played it back in my head, realized the gravity of my error, and saw that the jury realized it as well. And my opponent my opposing counsel was laughing uproariously. And I decided, well, I needed to do something. And the only thing I could think of was to go over and get down on one knee in front of my associate and apologize. And Anna played it perfectly. She crossed her arms. She looked down her nose at me and then accepted my apology. And the jury actually clapped. And so that was the situation. And I found this to be the case over the years. When you're in the most trouble, you can sometimes make the most headway if you're not so worried about how you appear and your own pride, and are willing to take responsibility for your mistakes and do it immediately and spontaneously. The jury recognizes that. And as in most of my cases, if allowed, I interview or have interviewed by a third party the jurors after the case. And one of the comments of the jurors was that when she saw me go down on my knee, she realized I was a real person. Mm-hmm. And I felt that was a very, very big compliment that I had unfortunately had to earn in that case. They also said, one of the jurors said that they were proud of Ms. Davis, that she had stood up with all the big guys and done just as well as they had. And I thought she was by far the youngest. She was the only female. They had 7 male partners, and she did a terrific job, and those accolades were appropriate.
That's a great story, and it just shows you talked about at the outset your confidence and Anna's confidence, but it quickly turned into humility and the ability to show the jury that you, like you said, are a real person. I see this as analogous to the use of experts. Experts are going to be confident in their abilities, their expertise, but on a daily basis, attorneys that we work with come to us looking for an expert who can explain things in layman's terms to a jury and do so in a way that's not pompous or pedantic and so on. So it just reminds me of that, and it made me think, are there instances in your over 35 years in practice that are notable in terms of your use of experts as well?
Oh, absolutely. Quite a few. In fact, you bring to mind, I've often found that an expert who doesn't deliver 100% of the opinions that you want, but delivers the opinions that he does with complete sincerity and answers your opponent's questions straightforward and in an informative way, even when the answers are not helpful to your case, turns out to be the best kind of witness you can have. He's absolutely believed by the jury, and as long as on balance he's on your side, that weighs heavily. On the other hand, an expert who is clearly an advocate, who fights with the attorney that's questioning him, who will not give a response that's going to be negative to the side that retained him, even though he knows he would have to if he answered the question, and that's often perceived by the jury as well. And that does not turn out well.
Well, I know you have said that on the other side of things, cross-examining an expert is an adrenaline-charged pleasure. Can you elaborate on that?
Oh, absolutely. In fact, in that very same case, my damages expert on the other side, very, very good gentleman, truthful gentleman. He was, in fact, given several assumptions to make over the course of the case. And he made those assumptions and arrived at his opinions. And he had, in fact, made 5 different assumptions. And I was very careful during the trial to go over each of those assumptions with various witnesses and show that those assumptions were incorrect. So prior to the testimony of damages experts, I had completely undermined all 5 of his assumptions. He was put on the stand one day at about 2:00 in the afternoon, and he went on to 450. And he was very persuasive, a very good witness, and did very well. And Judge also said, "Well, Mr. Watkins, it's 10 minutes to 5. I'm going to adjourn till tomorrow unless you believe you can cross-examine this witness in 10 minutes. And I said, "Your Honor, I believe I can." And we went from a point in the day where the jurors were all tired, the judge was ready to stop, everybody got on the edge of their seat. How in the world is this witness going to be cross-examined in 10 minutes? Well, I'm pleased to say I was able to do it in 8 minutes. And the way I did it was just to go through each one of the assumptions he had made and get him to admit that if that assumption was incorrect, then his opinion that would vary his opinion. And finally, when I got through the 5th assumption, I said, "If all of these are incorrect, would that change the thrust of your opinion in this case?" And he said, "Yes." I said, "No further questions." And it was not a problem that the expert had himself. It was a problem with the assumptions that he had been given.
Interesting. Well, I think that example really illustrates the importance of preparation for cross-examination of a witness, the way you methodically challenge their assumptions, but also the vital importance of your opposing attorney's preparation and coordination with their own witness. I wanted to go back for a moment, if I may, Kirk, to the topic of writing and the importance of persuasive writing in litigation. Tell us about the role of persuasive writing in your practice.
After exposure to my high school buddy who I thought could write like Bob Dylan when he was in the 10th grade, I felt like I had a lot of learning to do. But by working over the years long and hard, I focused my writing more and more and found that the best way for me to present a case. I learned some things slowly. I love to use analogies, colorful analogies, and I learned that those are not as effective. They're fun for the person to come up with, and they're fun to say, but they're not as effective at persuasion. I also have encountered any number of lawyers who use extremely strong adjectives in describing the strength of their case and the weakness of their opponents, such that there's some lawyers that every case they have is the strongest case they've ever had and their opponent's the weakest case they've ever seen.
Right.
And I also found that is not necessarily as persuasive with the court. So over time, I've adjusted to try to write my briefs in a form or a structure and form that I refer to as persuasive neutrality. I try to use as few adjectives as possible, but to select the way I describe facts in ways that are favorable to my client as opposed to favorable to the other side, but not overly blown. I'm trying to describe a fact, not to energize with an adjective. I avoid the very, for example, is a term if you say something is very strong, it's really, in my opinion, weaker than saying something is strong. So I avoid that type of piling adjectives on adjectives. The other thing that's very important, I've found, is not to be critical of your opposing counsel. And sometimes that can be very difficult. I'll give you another example from my patent case that I had. We had a situation where there was some briefing involved, and we briefed and acknowledged to the court that we were relying on some authority that was not primary in the jurisdiction. It was not the general rule, but we thought it was the better way the law should be interpreted. And our opponent cited a case, and they cited it incorrectly. They did not give the correct holding of the case, and they advocated based on the incorrect holding that they had advocated for. And I was confident that the judge realized that we were trying to effectively make new law or to persuade the court to change existing law as opposed to making a frivolous or misleading statement. But I was similarly confident that my opponent was not doing that. Well, before the judge heard arguments on the motion that was involved, he said, I am very upset at counsel in this case. Y'all have not cited authority correctly or presented to the court arguments that are appropriate for the positions you've taken. And so he said, all right, he said, I'll hear argument. I said, well, Judge, could I respond to that, please? And boy, you could see the judge sit back. He was ready. He had made his statement, and he didn't want anybody to challenge him. Mm-hmm. And I said, Your Honor, I apologize to the court for any oversteps that we have made in our briefing. I can assure the court on behalf of myself, and I'm sure even for my opposing counsel, that we will make every effort in the future to ensure that the court is only presented with authority that is appropriately supported by what we cite. And the funny thing happened. The judge sat back and he smiled. He said, well, Mr. Watkins, I really didn't have as much of a problem with your position, sort of thing. But I accept the apology, and we'll move forward. And in that instance, again, it's sort of the humble thing. It's where rather than taking that aggressive action, well, it's not me, it's the other side, or rather than trying to defend myself, or even rather than just letting it slide, I aggressively went forward with an apology that took responsibility even for something I really didn't think was mine, and then the judge acknowledged that it really wasn't mine, but he liked the way that it had been handled. And again, I would say that's something for attorneys to keep in mind. I have actually found time and time again when I've made my worst mistakes and everybody makes them, and I've made some pretty big ones, but when I've made them, if I say directly to the judge that I realize I've made a mistake, here's what it was, and here's what I propose to do to correct it, that almost invariably that's accepted. When I tell my clients, here was an error in strategy. I thought that this would happen, but this happened. I made an error here. My clients have uniformly been supportive, and the court's uniformly been forgiving. And what it engenders in both of them is credibility.
Right, and credibility, needless to say, is so important. Once you've established it, you need to maintain it, because once you lose it, there's no getting it back. Switching gears a little bit, Kirk, I know that you have very diverse and unique interests outside of the practice of law, and that some of them overlap and really mesh well with some of your practice areas within the law, notably patent law. Tell us a little bit about those.
Always had interest other than just the law. But part of my feeling, and I'll go back a little bit. As I got into law school and was deciding what area did I want to practice law in, I found that every area I looked at seemed to have a funneling effect. You would start with a wide array of knowledge, and you would gradually funnel down to you were specialized in a little niche, and that was going to be the rest of your life. And that's not the way I had envisioned my life. Mm-hmm. I had envisioned myself more as entering the exit point of the funnel and broadening my horizons as I went through the practice of law. And as I went through law school, I found that the one area that seemed to allow for that was litigation. Because if you mastered the skills of being in the courtroom and arguing persuasively, and you could apply those skills to any type of different events and circumstances. And as I entered the practice of law, I found that even there you could be categorized. You could be just like a doctor can be a ear, nose, and eyes specialist or something, that you could concentrate on those type of injuries. There was a lawyer I know who was a fire arsonist specialist. All his cases were that. That's not what I wanted to do again. So once I was in litigation, how could I keep experiencing a very different experience every day? And everybody has different experiences, even if you're in the same little niche. But I like a broader range of experiences. And I found that intellectual property, and particularly patent law, patent litigation, really gave me that opportunity. And I've worked with any number of specialists who are just absolutely brilliant in their fields, and learned from them things that you would never know as an ordinary person if you didn't have that, if that wasn't your area of practice. But I have had outside interests that have eventually blended in with my legal career. And one of the first was back in the 1980s, when the game Trivial Pursuit came out. It pretty much took over the entire industry. It was a total bombshell. It was bigger in sales than any other 10 games had ever been together. And I tried to figure out, and started my mind working, what in the world made this game so popular? And I finally came up with a theory that the reason the game became so popular was because it combined two pre-existing very popular ideas. One was a game board, and the other was trivia, which was very, very popular at the time on radio and other game shows and types of that. Sure. So when I looked at that, I said, well, what else could you do? What other things are really, really popular that can be combined? And that started me on a career that was loads of fun, very informative, and never very lucrative, of trying to combine ideas that were already popular but had never been put together before. The first one that I wanted to do or tried to do was putting together a jigsaw puzzle and a board game. And that was, I came up with the name of the game as Jagger. And that game was designed to allow two players or two teams to race together to assemble their puzzles on game boards. And they would score points and draw cards that were worth a certain amount of points by completing a side, by playing all of the pieces to cover up one of the colors on the game board, or by playing a specially shaped piece that was in a jag piece, we called it. It was like a lightning bolt on a puzzle piece as a part of the puzzle. And that would be the biggest single bonus that you could get prior to completion of the puzzle. It was also a hexagonal puzzle, so there were 6 sides that every time you completed a side, you'd get some points. But the first person that completed a side would get more points than the second, and so forth and so on. So it was a race from start to finish, not only to complete the puzzle, but to obtain certain milestone points as you completed the puzzle. And ultimately, it could be designed with any picture in mind. JCPenney came around to the toy show one year and said they wanted an Old Testament game. So we had a puzzle done of David and Goliath and one of Noah's Ark. And boom, we had an Old Testament game that was out there. Also found that they could be cut in different sizes. So you could have puzzles that were 25 pieces for very young kids or puzzles that were 300 pieces for adults. And ultimately, we did an educational series where you would have one puzzle for the kid and one for the parent, where the kid's puzzle was maybe 100 pieces and the parent's was 200, sort of to even the abilities. But the funny thing was that we found when we did that the kids would work on these puzzles all the time while their parents were at school, and ultimately it was the kids that needed to put together the 200-piece puzzle, the parents did the 100-piece puzzle.
That's funny.
But did a lot of other things like that. We combined dominoes into a board game. So you, instead of matching numbers end to end, you matched colors and shapes building up. Did a word game that was a board game. It was not Scrabble also falls in that category. But what we did was one where you filled in a grid as you raced around a racetrack, and each word had to connect with the last one, and you threw dice. There were 3 different dice, and they would come up with 3 letters that you had to use in the word that you were spelling. But all of those were a lot of fun. I learned an awful lot about business, marketing, and employees, and all kinds of things in terms of running those businesses, which allowed me to work much better with clients over the years. And that being able to do that really, really helped me understand business issues much better than I otherwise would have. Payables, receivables,
right,
human resource issues, all those types of things. You just ended up dealing with all of them, and you learned a little bit about them, not at the same level, obviously, as the bigger businesses that I represented. Then, after a while, I decided that I would like to transform some of the games to computer games. So I taught myself computer programming and began programming some of the games, and that was a lot of fun. I never became a good enough programmer to program them to operate as fast as they should. I was able to complete the games, but they weren't as fast as I would have liked them to play, because I was using simplified language and probably too many lines of code. But what I found from that was it was extremely helpful for me in dealing with software programmers and dealing with patents that related to hardware or software, and copyrights relating to software, disputes over software licensing, all those things. I was able to learn from that and utilize that information in cross-examining witnesses and expert witnesses, which was very helpful.
Wow, that is really remarkable. Not only were you able to create these games and learn computer programming and about business, but apply all this new knowledge to your practice of law and have fun while doing it. That's really great. So switching gears a little bit to another pursuit outside of the practice of law, and this one is sounds like a lot of fun for you. Is it you and your wife who started the North Georgia Canopy Tours?
Yes, we did. Back in 2007, my wife and I took a trip to Costa Rica. We did a canopy tour, which is a zip line experience through the rainforest there. And we had a little property up in North Georgia. And I said, well, honey, I think we could do that. She said, no, we can't, but we can hire some professionals that can come in and design it. So we came back and we did that. We were just about to roll it out in 2007. We had some funds, borrowed funds lined up to put it in place, and the crash occurred. And it took us another 2 years to find investors, particularly another canopy tour that's still operating up in Ohio, Hocking Hills. Their owners decided to invest with us and help us launch North Georgia Canopy Tours, which we did and had 10 really good years up in North Georgia with that. We actually, at one point, had more Facebook fans than any other canopy tour in the world. And then we launched Virginia Canopy Tours after that in the Shenandoah River State Park. And that was successful for 7 years, and we thoroughly enjoyed that as well. Now we've ceased both of those operations, but in the North Georgia Canopy Tour site, we have the Disc Golf Course, and we're building this year, and we'll complete it this year, the Mossy Bottoms Disc Golf Course. And the Disc Lula course is ranked 55th in the entire world of over 6,000 disc golf courses. And we're pleased with that, trying to raise that rating as well.
Not until I spoke to you, Kirk, did I realize there was a professional disc golf association, and your course is part of that?
Absolutely. In fact, the president of the Atlanta Disc Golf Association at the time, back in 2010, designed our course, and his name's Keith Johnson, and it launched in 2011. And we now have a pro shop operated by the Bomb Squad on the premises, which is great as well. I did want to make a comment before we end today about working with the Roundtable Group and what y'all have brought to the table for me, because I have found that there are a lot of professional experts out there that promote themselves very effectively, and you can find them. But I've not found that though they're very experienced, they're not necessarily as authentic. And one thing I found with the Roundtable is you bring me a number of people to look at and to sift through and to talk with before I hire anybody. And a lot of them are academically oriented, which means they're comfortable on their feet. And what I want in an expert more than anything else is somebody that wants to teach the judge and the jury as opposed to persuade them. If I can persuade the expert that my side's right and that what we're doing is what he should be taught to the teacher, to the students, and to the judges, then he's going to do that. He's going to do that automatically, and he's going to do it very effectively. If I'm trying to get him to sell something that he may not fully believe in, I'm going to have a problem with him. And I found the Roundtable that's been, in every instance, has delivered to me somebody that will fulfill my objective of having somebody that the jury will believe.
Thank you so much for that, Kirk. We really appreciate it, and we're so glad to hear it. And we especially appreciate you being a loyal Roundtable Group client for over 17 years now. I can't believe I met you 10 years ago in your office at Womble Carlisle, and now here we are. Thanks again, Kirk. This has been a real pleasure.
Thank you, Dan. It's been a pleasure, and may you have many more.
Thank you, Kirk.
All right.
Be well.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.